All right, wait, wait, wait. Please be seated.
Mr. Jodish, please proceed.
And so to move to a conclusion, the defence case will show that the prosecution interpretation of this joint criminal enterprise is but a blunt instrument. It fails to accurately define the criminal purpose, fails to identify when it may have begun with any precision, and it fails to distinguish Mr. Stanisić's actions from those actions in furtherance of a criminal purpose. The operations at Tara, the Drina operations, the operations at PAOK, and the operations in 1995 are an eloquent demonstration of that submission. The evidence will show, as we've outlined, that these were legitimate military operations. Of course, it was of concern, and the consequences were grave, that these operations involved certain criminally disposed men. However, that does not make the essential lawfulness of the military objectives unlawful or make them part of the JCE alleged. Those who can be shown to be responsible for the sending of Arkan and those who committed crimes have a case to answer, and those who can be shown to be criminally responsible should pay the price. And the defence will demonstrate that Mr. Stanišić had nothing to do with the choices which led to those crimes, and nothing to do with the crimes. As I've indicated, the story of the Red Berets is much more straightforward. It's not even nearly as dramatic as the prosecution witnesses and some of the documentary evidence implies. Some of the men who may have committed crimes may have been employed temporarily by the DB. But that doesn't make them forever and a day the responsibility of the DB, or particularly of Mr. Stanišić. We rely upon the fact that Mr. Stanišić had no role in choosing and employing these reserve forces. Had he been able to micromanage the state security in the way suggested by the prosecution case, then he couldn't have fulfilled his essential duties. It is tempting to reach for simplistic answers and coherent stories, and the story of the Red Berets is one such tale. It is a caricatured description, akin to a James Bond movie, with Mr. Stanišić, the caricatured devil, at the centre. We submit that Mr. Stanišić and the Serbian mob has been demonized by the press, by the Serbian mythology, and lastly now by the prosecution witnesses. We submit that the evidence will show that he did his best to create security within Serbia for those and all of those who are endangered by the war. And that is why his service became involved in the operations towards the end of the war. We submit that it is easy to point to sections of exhibits and easy to take evidence out of context. The defence will provide that context. If I may just refer Your Honours to slides 51 to 61. Sorry, 56 to 61. In some ways, it's a microcosm of the role Mr. Stanišić played in the defence case that we will prove. It relates to the period of the Banja Luka operations. Mr. Stanišić, in slide 56, is clearly engaged in trying to find the two pilots, French pilots, who have been taken hostage by the hotheads from Parle. Your Honours will see on slide 56 the view of Mladic, that Jovica is looking for the pilots, and there is no doubt that he does not like Slobo. Your Honours will see from slide 57 that Stanišić is playing one of the often games he was forced to play. Bluff and double bluff is the role of an intelligent man. Telling Mladic what he needed to tell in order to find the French pilots. Saying he was exposed and working without the knowledge of Milosevic. And if we move further down slide 57, we see there that Mladic, presumably on information, presumably having discussed with the VRS High Command, notes that a team from the Serbian DB has arrived. They are Filipović and Bozović. They arrived. Bozović was a member of the reserve forces. He was forever associated with the DB from the early days. It's telling that these are the men identified as belonging to the DB. 300 Arkan's volunteers arrived. Mladic doesn't associate them with the DB. If Mr. Stanišić had had this long-standing arrangement and relationship with Arkan's men, he would have known that Arkan's volunteers were part of the team from the Serbian DB. And we turn to slide 58. And can I ask, please, just briefly for P2545P1 to be put on the screen. The slide 58 has Stanišić saying, there is no command there, political conflicts, cities are falling, Arkan is embedded there, we sent 400 people. We dispute that Arkan is embedded there is precisely the right interpretation. The right interpretation involves a meaning which effectively says that Arkan put himself there. In any event, even if Your Honours don't accept that, it is most telling that Jovica says, in a list of chaos, in a list of problems, there is no command there. Political conflicts, cities are falling, Arkan is there. Why does Mr. Stanišić put that in a list of problems if he personally sent him there? And meanwhile, Mr. Stanišić looks for the pilots. we look over the page to slide 60, Mladić's notebook entry of the 3rd of October 1995. Filipović notes, Arkan's men are operating under the control of Pekanach, and he expresses approval for that. And that's what the prosecution rely upon. They rely upon employees of the DB themselves forming individual relationships with the likes of Arkan and then attributing that to Mr. Stanišić. Bozovic on slide 60 notes that they came with a task referring to the Serbian MUP, a task that they were aware of. It was agreed that that they would replace the RS police, and the RS police would go to the forward defence line. This was agreed with President Karadzic and General Milanović. An illustration of what our defence is, because we submit that the Banja Luka operations involved the Serbian MUP, and it involved the Serbian MUP who sent men to replace the RS police who were being dragged into the conflict. And the idea was that the Serbian MUP would replace and conduct normal security duties. That was agreed with President Karadzic and General Milanović. And then at the bottom of slide 60, Your Honours will see a reference there to Jakov Jovic. People are openly asking who brought Arkan and under whose patronage they are doing this. 1995, it appears that no one at that time from the VRS High Command associated Arkan with Stanišić. If there was a glimmer of truth in the prosecution case, he would have been known as Arkan, as Stanisić's man. And meanwhile, Stanišić is looking for the pilots. And then over the page to slide 61. Another demonstration of the demonization, we suggest, which has taken place in relation to the Serbian MUP. Mladić notes he has a meeting with the inner circle of the General Staff of the VRS. And he notes that already for 4 days, no resources have been coming from the FRY, and the Serbian MUP has probably put the border under its control after Arkan was chased away. So there you have it, the Serbian MUP controlling and preventing Arkan from working. And there you have it at the bottom of slide 21, Mladić noting that they have a problem with the RS MUP after Arkan was chased away, and Toma Kovac, Minister of Interior, does not accept the order and the use of the military police. In other words, there's the association. Arkan was invited by the RS MUP and prevented from returning by the Serbian MUP, and therein lies the prosecution case exposed. And so finally, turning to prosecution exhibit P690, and the prosecution put some weight on this because in reality it's one of the very, very few comments from Mr. Stanišić which might be construed as indicating support for any criminal enterprise. We submit it is pre-war bravado. A proper analysis of that discussion shows that the discussion revolves around a peace agreement and the necessity for bringing people like Babic, extremists, to the negotiating table. And Stanišić uses inflammatory language. It is not an indication of his mens rea. It's an indication of pre-war bravado and frustration that others will not accept peace. And if we go over the page to line 63, the section missed out by the prosecution, where Stanišić says, if they want it, they'll have an all-out war. Yes, yes, says Stanišić. Stanišić answers, better do it like decent people. And in our submission, that's what the defence will show. That Stanišić did it like a decent person, because, as the witnesses will confirm, he is a decent person. And whilst cities were falling, and whilst Arkan placed himself there, Stanišić was doing what he did, trying to secure Serbia by rescuing the two pilots, trying to secure that peace would come and that Serbia would not be dragged into the war. And that will be the defence case. Thank you.
Thank you, Mr. Joras. Just Mr. Bakrac and Mr. Petrovic, from yesterday's pre-defense conference, the Chamber understands that you are waiving your right to make an opening statement at this stage of the proceedings. Mr. Groom has expressed some concerns about compliance with Rule 65(F). I just want to emphasize that, of course, if you choose not to make an opening statement, that in itself does not mean that if there are changes in the nature of the accused defense, then of course it would be appropriate to report that, and I take it that Mr. Groom will keep a close eye on how you will proceed during the Stanišić defense case and the Simatović defense case to see whether the concern reaches levels which ask for action. Until now, it was just an expression of concern.
That's correct, Your Honor.
Then I'd like to leave it to that at this moment. I was informed that Mr. Groom would like to raise a certain matter in relation to protective measures. Are there any other matters the parties would like to raise? Ms. Joras, I see you are nodding no. I do not see any positive response from the Simatović defense. Therefore, I take it that we only have the one issue to be raised by Mr. Groom. Mr. Groom, do we need to go into private session, or is there no need to do that?
I don't believe there's a need, Your Honor.
Then please proceed.
Thank you, Your Honor. And just so it's clear, this is unrelated to the opening that we've just heard. It's a different matter. On the 27th of September 2010, the defense for Jovica Stanišić sought access to all confidential inter partes materials in the case of Prosecutor v. Simic et al. The trial chamber granted this request on the 24th of March 2011 with certain limitations. Specifically, the trial chamber's order required the extraction of several different categories of material. And that is the title of that decision is Decision on Request of Jovica Stanišić for Access to Confidential Materials in the Krajisnik and Simic et al. Cases. Subsequently, the defense for Franco Simatović saw access to the Simatović material on the 2nd of June, 2011. In the process of drafting the response to the Simatović request, the prosecution realized that the Simatović defense was previously granted access to all inter-parties confidential materials in the Simatović case on the 12th of April 2005. And this was a decision rendered by the appeals chamber under case IT 95-9-A, entitled Decision on Defense Motion by Franco Simatović for Access to Transcripts, Exhibits, Documentary Evidence, and Motions filed by the parties in the Simatović et al. Case. The respective defense teams of the Simatović case and the prosecution reviewed the material that the appeals chamber ordered to be reviewed and informed the registry that there were no issues related to protective measures or Rule 70 that needed to be resolved prior to giving the Simatović defense access to this material. The materials were provided on a CD to Mr. Jovanović, then counsel for Mr. Simatović, on the 20th of July, 2005. As a matter of fairness, the prosecution considers that both the defense teams should have the same access to confidential materials in the Simatović case. Thus, the prosecution seeks this trial chamber, or requests this trial chamber, to vary its decision of March 2011 to bring that decision into conformity with the appeals chamber decision of the 12th of April 2005, and to order the prosecution to turn over the same materials that have been previously provided for the Simatović defense. I provided courtesy copies of the appeals chamber decision earlier today. If the chamber grants this request, the prosecution has identified no additional confidential inter-parties materials subject to Rule 70, and we have located the CD that was provided to the Simatović defense in 2005 and would be able to disclose that forthwith. Thank you, Your Honor.
Thank you. Any response or any observation?
Only, thank you.
No, Your Honors. Everything is as indicated by the prosecutor.
Yes, of course, apart from that you were asking on the 2nd of June the same material you have received before. So if you say let's leave it to that, let the chamber write a decision on that, is if that's your intention, I cannot assure you that we'll follow that suggestion.
Ne. Časni sud.
Your Honor, my apologies. I thought we wanted to wrap up soon. We weren't familiar with this. That's why we weren't able to locate the detail about Mr. Jovanović, and the decision dated back to 2005. So that's where the misunderstanding stemmed from. And the filing concerning Mr. Jovanović dated back to 2003, and we weren't able to locate it.
I'm not blaming you for having difficulties in finding the CD-ROM, although I would, to the extent it has not been done, I would perhaps advise you to go through the list of decisions in this case so that you didn't miss one, which saves a lot of time in writing new motions, which cover the same subject matter. But may I take it that what you just said is a oral withdrawal of the 2nd of June motion? Is that how we have to understand your submission?
Da časni.
Yes, Your Honor. I was just about to state that, but for the reasons I mentioned and the problems we had with locating late Mr. Jovanović's material, we kindly request the OTP to hand the specific material over. That's the material we were already given back in 2005, and we withdraw our application.
Mr. Groom.
Your Honor, that was provided, if Mr. Bakras will recall, in October of 2009, he requested that we redisclose all of the material provided Mr. Jovanović, and this material was provided on the hard drive that the defense was given. And if he has any trouble locating it, we'll, of course, redisclose again.
Yeah.
Okay, that then seems to be resolved if Mr. Groom will assist you in ensuring that you have this material available, whether or not it's already in your possession, whether it's once or even twice in the possession of the Simatović defense. And you were about to say that you would withdraw the motion, which is now put on the record.
Yes, Your Honor. Mr. Groom and our defense team will work together to try and locate the material. And for the record, I do withdraw our motion, yes.
That's on the record. Then the matter itself, this chamber, Mr. Groom, you very much emphasized the equal position for both defense teams. Now, I'm not going to comment on what happened in 2005. What I can do is to briefly comment on what we did in 2011. In 2011, this chamber established that and in that respect, referring to submissions made by the prosecution, that there are categories let me just have a look. That there are categories which include remuneration, provisional release, fitness to stand trial, registry submissions of expert reports on health issues, notices of non-attendance in court, modalities of trial, protective measures, subpoenas, applications for video conference links, as well as orders to redact the public transcript and the public broadcast of a hearing. We considered that the applicant had no forensic purpose for access. Now, the question then arises, what is more important? Equality between the parties. One of the parties having received material, or at least I do not know whether it exists at all, but at least not where access is not excluded from material which this trial chamber considered to have no forensic purpose. Now, what to do under those circumstances to restore equality by giving to the Stanišić defense also material which serves no forensic purpose? There was no request for a certificate to appeal this decision in this respect. It was emphasized by the prosecution that this did not serve any forensic purpose. Now, what is more important, to restore equality by giving to the Stanišić defense material which we consider totally without purpose to give it to them, or to say, let's leave the inequality exist as it does exist, and not further add to access to materials which, in the view of this chamber, no access should have been given to. At least the appeals chamber at the time was very much concerned about the difference between inter partes and ex parte material. Well, that's not an issue that arises here. So before the chamber will decide, Mr. Jordas, are you interested in receiving materials without a forensic purpose, just in order to restore equality in this respect?
Well, I can probably speak on behalf of our beleaguered case manager, and the answer is no.
Yes. Now, Mr. Groom, thinking about a further distribution of, I would say, material, often with some kind of a privacy element in it, and without a forensic purpose, would you, also in view of the answer given by the Stanišić defense, would you insist on your motion, your oral motion, that the chamber would vary the protective measures?
No, Your Honor, I am not going to insist that the Stanišić defense accepts something that they do not want. I guess one of the considerations that prompted this was that I know that the two defense teams do have some cooperation, and if one had some material that the other didn't, were we setting up a situation where there could be an inadvertent violation of an order to?
Yes, now I do understand that the defense teams, both defense teams, are so much short of time that they would certainly not discuss matters which have no forensic purpose at all. That's at least my expectation. Under the present circumstances, may I take it that the Simatović defense, again, I do not know whether there's any provisional release material in the Simic. You would not know either because you don't have the material, but would you, if you receive it, would you please carefully look at whether there's any material of those categories which we listed in the decision on the Stanišić motion for access, and to avoid to discuss that with the Stanišić defense, because it is in your hands. It is confidential material. It is not accessible to the Stanišić defense, and they have no problem with that. So if you would be very strict on that, no errors or no mistakes will occur.
Da, časni sud.
Yes, Your Honor. We'll proceed as best we can, and we'll follow your guidance.
There's even another option which you could consider. The decision of the appeals chamber is there, and this chamber, of course, is not in any way competent to even discuss this decision. But in view of the chamber's decision and in view of the access granted to the Stanišić defense, you could even invite Mr. Groom, when again supplying you with the information, to leave out what is not given to the Stanišić defense and not insisting on having full disclosure of these materials. Mr. Groom, you must have two sets, the old one and the new one, the limited Stanišić one. So I leave that entirely in your hands, whether you want to make such a request to the prosecution or not. It would at least restore, in practical terms, the equality.
Sure.
Mr. Groom, may I take it that from your earlier observation that your oral application is withdrawn?
Yes, Your Honor.
Yes. any other matter to be raised at this moment? If not, I would like to inform the parties that they will soon know whether next week, Friday, which is, if I'm not mistaken, the 24th of June, that you'll be informed about whether we'll hear the evidence in the morning or the afternoon, and there is a fair chance that it would be in the afternoon, and I put you already on notice before you make any travel arrangements that there's a risk that it will be in the afternoon, and but you will be informed as soon as possible. If there's no other matter, we stand adjourned and we resume Tuesday, the 21st of June at 2:15 in the afternoon in courtroom 2, I take it. Madam Registrar, could you confirm that? Yes, it is hereby confirmed. We stand adjourned.
All right, we avoid.